It's been nearly 1 year since the Supreme Court ruled on Citizens United versus the Federal Election Commission. The verdict says government cannot put a cap on the amount corporations or unions spend on campaign contributions. One group called MoveToAmend.org says corporations are legal fiction. We'll discuss on West Michigan Week. And thank you for joining us on West Michigan Week. On the panel, Jim Harger. MLive Media Group is the new name, no longer the Grand Rapids Press. How are you doing, sir?
Good. Well, there'll still be a Grand Rapids Press as well. It's just who's writing my paycheck. Well,
hopefully the man who's writing your paycheck will be on the show in the coming weeks.
Good.
And David Cobb is here from MoveToAmend.org. Thank you so much for joining us. You're in town. Occupy Grand Rapids invited you in. You were in Grand Rapids speaking at the Fountain Street Church. Tell me a little bit about Move to Amend and this whole idea of the disagreement with the Supreme Court ruling last year.
Well, Patrick, Move to Amend is a multiracial, multi-ethnic coalition of a number of groups and organizations, both national, state-based, and local, all that have united under a singular demand to abolish the legal doctrine that corporations are persons with inherent inalienable constitutional rights, and to abolish the doctrine that money is speech. Those are two separate but very important legal doctrines. Not one law. In fact, these were created by the court, but two separate legal doctrines created by the court that has allowed, in our opinion, the corporate money to come washing into the system to basically overwhelm it. And so we're calling for a constitutional amendment.
Well, let's take a look at the opinion of the court, because that's the most important thing right now, and then we can discuss your feelings on that. Here's the majority opinion. Let's get the graphic up here. This is Justice Kennedy, who penned, if the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. And on the dissenting side, this was pretty split down the middle, too, as far as the justices go. Here's what Justice Stevens had to say. He says, at the bottom, the court's opinion is thus a rejection of the common sense of the American people who have recognized a need to prevent corporations from undermining self-government since the founding, and who have fought against the distinctive corrupting potential of corporate electioneering since the days of Theodore Roosevelt. It is a strange time to repudiate that common sense. While American democracy is imperfect, few outside the majority of the court would have thought its flaws included a dearth of corporate money in politics. Well, Justice Stevens had a lot to say there. I take it you come down with Justice Stevens here. Where is the rift? Why do you think the majority opinion came down the way that it did?
Well, bluntly, I think because the majority of this current court is the most highly politicized court that we've seen probably in at least 50 years, maybe 75 to 100 years. My contention would be that this was an ideologically driven issue, because let's be clear that this decision, Citizens United versus Federal Election Commission, overturned 100 years of precedent, which had made it clear that it was appropriate for state, local, or federal government to enact reasonable campaign finance restrictions to protect the integrity of our elections.
So the issue really is that lobbyists are controlling government at this point.
Well, let me ask you to put it bluntly. What problem do you see that you're trying to solve here?
Well, there are two, and that's the reason why corporate personhood and money is speech. First of all, corporations are not persons. They do not have inherent inalienable rights. A corporation is a legal fiction. It is created by the state chartering process, and that includes, by the way, for-profit and non-profit corporations. We at Move to Amend do not believe that for-profit corporations have inherent inalienable constitutional rights either. You have it, Pat Buchanan has it, Ralph Nader has it, because we're human beings. So one problem is the idea that a corporation or corporate lawyers can go into court and overturn democratically enacted laws that are attempting to control the conduct of those corporations. It is illegitimate, whether it's a campaign finance law, an environmental protection law, a worker safety law, a public health law. Corporate personhood writ large, we believe, is an illegitimate diminution of the people's ability for self-government. The second idea is money is not speech. Money is property, and if you allow unlimited amounts of money in elections, what you've basically done is allowed whoever has the most money to overwhelm the rest of us.
Are you seeing that? Can you point to an example?
Well, how about this? The fact that since 2008, every election cycle that we've seen in the United States has become almost exponentially more expensive than the last. We know, in fact, in 2010, November 2010, after this Citizens United decision, that for the first time in the history of our country, foreign governments and foreign corporations were able to legally spend money to influence the electoral system in this country, and we don't even know who they were because they don't have to actually tell us who they are.
But you're still trying to convince voters, I mean, to vote for one person or another. How is that being thwarted just because elections have gotten more expensive?
Well, it's not just that they've gotten more expensive. It is that, I mean, polling data shows that exposure to an idea over and over again ends up shifting opinion, and we can look at any number of examples where that's happened, Jim. And I think this is the important thing. We are dedicated not to the idea of different issues. It's important to recognize that the Move to Amend coalition is not just multiracial and multi-ethnic, but transpartisan. We have principled liberals, principled conservatives, moderates, folks all in between. What we're saying is we need a level playing field for a public discourse that actually delves into the issues. Frankly, let's be honest, these 30-second ads, which have become what passes for political discourse in this country, is not for the benefit of the body politic. We're not actually having the kind of thoughtful public discourse that we ought to be having in our elections.
So if your amendment passes, let's say it passed, let's assume it passed 2 years ago, how would this year's election and campaigning be different?
Well, I suspect well, first of all, what it would mean is that if it had passed, then we would have a debate over what local, state, and federal governments think is an appropriate level of restrictions in elections. Because remember, we're not mandating anything at the constitutional level. We are merely saying that we, the people, have the democratic right to decide through our elected representatives how to properly protect the integrity of the elections. Right now, it is clear that corporations, unions, wealthy individuals can spend unlimited amounts of money in independent expenditures to try to influence the process. All we're saying, Jim, is that the working of our democratic republic should allow our elected representatives to speak for us and protect our elections.
And this is where Attorney Devin Schindler would have jumped in. He would have been here on the panel. He couldn't make it today, but he did leave me with thoughts on this. He disagrees. And here's what Attorney Devin Schindler has to say. He says that you have the right to invest in corporations or join unions who share your personal values. That's where he comes down. Here's what he has to say. The Constitution as written embodies a strong presumption in favor of speech. The whole theory of the First Amendment, and therefore our government itself, is that truth can best be derived from the cacophony of voices competing in the marketplace of ideas. He goes on to say, the Constitution also recognizes that the most powerful speech comes from groups of like-minded individuals joining together to speak with one voice. Hence, a labor union speaking for hundreds is more effective than one lone laborer crying out for fair wages. The message or motive of these groups of people is essentially irrelevant. Speech designed to increase my well-being, i.e. my motive for speaking is to make more money, has as much value, say, as speech designed to save the whales. In other words, the last thing we want is government telling us your speech has less value. The purpose of the marketplace is to allow individuals to make that determination. And we go on. The proposed amendment troubles me because it is a form of censorship that goes against our strong commitment to free speech. When I invest in a company, I am making a statement, i.e., I like their product, I like their stand on social issues, I believe that they are an ethical company, etc. The same is true when I join a union. When the company or union in turn speaks, i.e. vote for Obama, he supports the kind of alternative energy windmills or the windmills the company makes, they are more effectively communicating an ideal, by definition, support. Otherwise, you could quit the union or sell your shares of stock. Simply put, this is not a case about corporations having rights. It is about my right to join and invest in organizations who share and communicate my values. And that was Devin Schindler from the Thomas M. Cooley Law School. Did you get all that?
I did.
Okay.
And I'm really sad that Devin was unable to join us, because I think he and I would have had a very rich discussion and debate, and we would have done it civilly and showed that it's possible to do. I will say that I believe that Devin has completely shirked the question of who is a person with rights to begin with. I will agree with Devin that he has an individual right to associate, he has an individual right to speak, he has those rights. But when he gets together with somebody else to form an entity that only comes into being if the state issues a charter, the state chartering process creates this entity to get limited liability, to get the various privileges that one may get under that chartering process. It is appropriate for the state to be able to say what that entity can or cannot do. The corporation does not have a mind or a body or a conscience or a heart or a soul or any of those reasons why we say we have inherent inalienable rights. So with absolutely respect to the difference of opinion, our opinion is different, and it is sharp, and it is distinct. Yes, I absolutely am a civil libertarian and believe in individuals' right to speak and to associate and to be free from unreasonable search and seizures, but it is illegitimate to transpose those rights onto artificial entities.
But if you go down that road then, and if the Supreme Court had ruled differently, there would have been a cap on finance spending?
Actually, all that would have happened was that the McCain-Feingold law would have stood. That's all. The Citizens United versus Federal Election Commission stripped away one of the most popular federal campaign finance laws that we had ever had in this country, and it was very weak to begin with. It was very weak. We still had a flood of money in elections, and it was McCain-Feingold. You remember John McCain, Republican, Russ Feingold, Democrat. This was a bipartisan effort that had broad support not only in Congress but through the American people. And the question really is, who rules in this country? Is it going to be we the people, those sacred and hallowed words, or is it going to be unelected and unaccountable corporate CEOs? Because I think that's what's reflected today, and I just want to underscore the fact that 80% of the American people are actually with us. Democrats, Republicans, independents alike believe this idea of corporate personhood doesn't make any sense.
We're going to take a quick break, and when we come back, we'll discuss more Move to Amend in just 1 minute. And we're back. We're going to pick up the discussion here on the Move to Amend and talking about the Supreme Court ruling last year, which really has its roots here in Grand Rapids.
It does. It was a case of Austin versus the Michigan Chamber of Commerce. Austin was Richard Austin, our Secretary of State. And back in mid-1980s, there was a state special election for a state representative in which the Chamber of Commerce wanted to take out an ad. Now, they did this as a test case. This was an ad in which they talked about the issues in the election, and at the end they said the magic words, "Vote for Richard Banstra." If they would have left that out, the ad would have been fine. The Grand Rapids Press would have taken it. There would have been no court challenge, but they wanted those words in there. A federal judge here in Grand Rapids upheld that law after a 1986 trial. The Sixth Circuit overturned them. The Supreme Court went back and upheld the law, and therefore you were restricted. My question is, under Austin and under that ruling, you still had chambers of commerce, business groups, Sierra Club, whatever, putting out these issue ads, and you kind of had to figure out, did they want you to vote yes or did they want you to vote no? Did they want you to vote for Joe or Tom? Now it's pretty clear. You know, it's pretty clear who these ads are promoting or what issue are they promoting. Is it worth it to have that veil that Austin put up or demanded?
Well, actually, Austin didn't demand it. The court did, and actually the case preceding it, which was Buckley versus Vallejo and then First National Bank versus Bellotti, because when we delve into it, this whole idea that money is speech, which is back to the move to amends position, is an illegitimate legal doctrine that was only created in the 1970s in this country. Because, Jim, I agree with you that this veil of pretending like simply because we don't say the magic words of vote for Joe somehow makes it an issue ad and not an electioneering ad was a farce and a falsity to begin with. Our position is this, that it is appropriate to allow local government, state government, and federal government, you know, our government, to actually make appropriate campaign finance laws to protect the integrity of the electoral process. And it's worth pointing out that poll after poll shows that the American people believe that they cannot have confidence in our own elected representatives, and in large part it's because they are seeing either direct corruption or, and this is the magic word, the appearance of corruption, which has undermined the integrity not just of our elections, but public confidence in the United States of America and our own government and our own society. This is corrupting, it is corrosive. Corporate money and special interest money of any variety is like a cancer that is mastatized within the body politic. And we're saying, let's give our elected representatives the chance, locally, state, and federally, to make the determination. And frankly, if the good people of Grand Rapids say they want unlimited amounts of money, I would say it's their right to do so. And let's actually let that public discourse take place for real, and then allow the courts, force the courts to uphold that. Because here's the kicker, and we're back to it again. Only individuals have inherent inalienable constitutional rights. Corporations don't have them.
So Joe Moneybags can spend all he wants, or should there be limits on individual expenditures in an election, even though you're not doing it to the under the corporate structure?
Jim, that's a perfect question, because now, so are corporations persons with constitutional rights? That's one question. Is money speech? That's the other. We at Move to Amend do not believe that the wealthy should be able to spend unlimited amounts of money and nobody else. And it is appropriate if Grand Rapids, if the city of Grand Rapids, through its political process, decides that they want to allow unlimited amounts of money, that should be their right to make that determination. I guess what I'm saying is this. Let's pull away the charade and recognize that this Roberts Court and this entire idea is the most activist court in the history, in recent history for sure. And they are overturning laws locally, state, and federally, and then inserting their own judgment on it. It is inappropriate to do that. It is appropriate for we the people, through our democratic process, to decide what the rules ought to be for campaign finance.
This includes unions then?
Absolutely, and that's why I'm so proud that the Move to Amend is very clear that unions do not have these inherent inalienable constitutional rights to spend money in elections either. And it's part of the reason why we have so successfully been able to bring principled conservatives and principled liberals together to say, we may disagree on issues, but in terms of just the basic idea of the rules of how our government is going to operate, let's agree that corporations aren't persons, money is not speech, and then we can debate.
But individuals also have minds that think. If you watch Comedy Central, if you watch Colbert or Stewart, and you've got Stephen Colbert now with his super PAC, I mean, it's sarcastic, it's cynical. The whole point is these ads are so over the top now. It's almost as though you can see right through these
Listen,
things.
but that's true of all ads, isn't it? I mean, you know,
But shouldn't people be able to decide? I mean, at this point, when you had certain interest groups lobbying Congress that pizza is a vegetable, I think at this point, at least in my mind, it does almost become comical.
Well, I think, let me put the question this way, because I think this is what you're getting at. Is there enough transparency in the system so that you know who's behind the pizza as a vegetable? Sure. You know Stephen Colbert is just kidding. Is there enough transparency in the system?
Well, there's no transparency now because these monies can actually, that's the whole phenomenon of the super PAC, is that you don't actually have to identify yourself if you don't want to. And in fact, the U.S. Chamber of Commerce actually pretty clearly went out and solicited foreign corporations and used that money because it came into the same pool that they used to spend in the last election cycle. That's pretty darn problematic. But I guess we really keep coming down to the same question of, do we believe that we the people have the authority and the sovereignty to actually make the decisions about how to protect the integrity of our electoral process? Because whether or not we want, you know, any restrictions at all or some restrictions, those are all perfectly valid political debates that ought to be taking place. But what the Citizens United case has said is, we're taking that political process off the table. You don't get, doesn't matter what you want, doesn't matter if 99.9% of the citizens of Grand Rapids came together and said, we would like these campaign finance laws. The Supreme Court said, you can't do that.
Let's talk about your strategy. How are you going to make this happen?
Listen,
it's a great idea, you know. You can, but how are you going to make it the 28th Amendment? What needs to be done, and how are you going to prevent corporate America, the corporate world, from, or the organized labor, whomever's against it, from shutting you down?
So, Jim, first of all, let's acknowledge that what is implicit in your question is this is a heavy lift. Mm-hmm. Right? I mean, amending the Constitution is probably the most difficult thing that one can do politically in this country. And with that in mind, it's about as heavy a lift and it's about as impossible to imagine as the success of the abolitionist movement, or women ever getting the right to vote, or the ability to form trade unions because it was a criminal conspiracy in most states to form a trade union in this country, or about as improbable as the civil rights movement being able to overcome Jim Crow segregation laws. I say this very candidly to say we acknowledge how difficult it is and will be, and why the Move to Amend campaign is so focused on local organizing. We are not going to this current Congress. We are coming to the citizens of Grand Rapids, and I'm on an 8-town/city tour of Michigan right now, where we're going to the local communities. Our strategy is to put this on the ballot. Let the citizens of every community in Michigan and every community in this country vote. Do you believe we should amend the Constitution to abolish corporate personhood and establish that money is not speech? Yes or no? And voters can, then we can have this conversation not just amongst ourselves and not just the viewers of this program, but can you imagine how wonderful it would be to have these kinds of first principles questions with your neighbors and in pool halls and bowling alleys? Because it wouldn't just be theoretical. The issue would be on the ballot. And so that's our plan.
If you get it on the ballot, don't you think you'll attract some attack ads?
Of course we will.
I was thinking along the same lines. Those corporations are going to hit back.
Yes, they will. And you know what? We welcome that because, frankly, then I think that will expose the hypocrisy. And what is interesting is everywhere we've gotten it on the ballot, we've won by about 75 to 80% of the vote. And it has shifted the political culture. We have actually put corporate America back on their heels, where they're having to think twice before they just go in and spend money, because we're now saying we are building a political movement, and we are moving within both the Democratic and Republican Party primary process. Look at the fact that now in New Hampshire and now going into South Carolina, that in the Republican Party primary, you've got Republican opponents decrying the amount of money that the super PACs have. Am I the only one who finds this ironic?
And you're also going to hit the courts on the anniversary of Citizens United. That's coming up in 2 weeks. Occupy the courts.
Yes, we are taking a lesson from our the folks at Occupy Wall Street, which has really captured the imagination of the American people. And January 20th is the 2-year anniversary of the Citizens United decision, and we've seen just an avalanche or a flood of money come into the system in a deluge, and American people are angry about that. So we are calling for a national day of action called Occupy the Courts. These are lawful, peaceful protests in front of federal district courts across the country. Why the courts? Because in our way of thinking, the courts are the scene of the crime. The American democracy has been stolen from us by these court-created doctrines of corporate personhood and money as speech. So we have to go to the courts, and that's what we're doing. Over 100 across the country, and in your community too.
Well, I used to report in courtroms. I don't know that I want to occupy the court.
We're going to be outside. We're going to be outside.
All right. Well, Jim Harger, MLive Media Group, thank you so much for being here, and our guest, David Cobb, with MoveToAmend.org. Thank you so much.
Thank you.
And thank you for joining us this week. We'll see you next week on West Michigan Week.